You're listening to the Texas Appellate Law Podcast. I'm Todd Smith.
And I'm Jody Sanders.
Our guest for this episode is Tad Bartlett. Tad is at Fishman Haygood in New Orleans, Louisiana. Welcome to the show, Tad.
Thanks. It's good to be here.
Well, we haven't had very many Louisiana lawyers on, but we had Jeff Richardson on way back when. I'm sure you're probably familiar with Jeff.
Yes. Yeah, I know Jeff.
He was one of our early guests talking about all things Apple and iPad, which is his area of expertise. But we're certainly pleased to have you on and talk about a little bit different perspective that you bring to things. Before we get into that, though, let's talk a little bit about your background and maybe what brought you to the law.
Sure. Well, I've been a lawyer now here in Louisiana for 25 years, which is a little hard for me to believe because that sounds like an awfully long time. But my background is I went from Tulane to clerking for Jim Dennis on the Fifth Circuit, which is really where I developed my fascination with all things Fifth Circuit, from the personalities behind the scenes there to the jurisprudence that was being developed there, and just the procedure that binds it all together. And I went from there to Lisco and Lewis here in New Orleans, where I did a lot of, more defense-oriented appellate work and got involved doing most of the different sections would bring me in on appellate things. I guess that's what you do when you have a new associate coming in from the Fifth Circuit. And I got really interested at that point in starting an appellate section. The firm wasn't as interested in having an appellate section. Maybe we can talk about that later when we talk about how to build and the sort of personal history of building an appellate practice. And ended up in a series of evolutionary moves on my own, running a little bit of an appellate practice, and then went in-house with a firm that I was doing a lot of appeals for. And anyway, here I am. Now I have my appellate section. It's a if you build it, they will come sort of situation. And Fishman has been really supportive of the idea of building the practice. And once we put it out there, people are coming, people are interested. And that's kind of the dream I've been shooting for 25 years.
Oh, that's great to hear. So how long have you been at Fishman now?
I've been here for a little over 4 years. Although I had been doing a large chunk substantively, aside from the appellate work, the substantive area I do a lot of my work in is environmental law, doing a lot of work for landowners on like oil field contamination cases and also coastal land loss cases, which is kind of a brand new area of the law that we've been building as we fly the plane. And the firm I had been at before I was at Fishman for about 12 years, we co-counseled on a lot of those environmental cases together. So I really knew the people here really well, knew how they liked to work, knew what their sort of emphasis was and what they looked for. So I've been here for 4 years. I've been working with these folks for 16.
You knew what you were getting when you decided to make the move over there, sounds like.
Yes.
So are you doing any, are you primarily working in federal court there in Louisiana, or are you doing state court work as well?
I'd say really for the last year or two, about 50-50.
Okay.
The federal workload is ramping up more, but gradually, especially on the appellate side, we're getting a lot of folks contacting us to do Fifth Circuit appeals for them, whether they're coming out of Mississippi or Texas or Louisiana.
You have the benefit of sort of home field advantage there, being in New Orleans, which everybody, for all the appellate lawyers, those of us that don't practice in the Fifth Circuit all that much are a little jealous of those who do, because you get to go visit your fine city for oral argument. And I usually eat very well while I'm there. So it's always a fun experience.
You may eat better as a visitor than we do as the home field folks. Not to speak ill of what I get to eat when I go home, but it's not Commander's Palace every night.
Yeah, you've identified probably my favorite spot, and we could probably tell a couple of stories about that. Post-oral argument, lunches or early dinners at Commander's Palace. But I bring up Louisiana, state court work, because for those of us in neighboring states who are also in the Fifth Circuit, we don't really know much about it other than to know that it's different. Civil law system.
Everybody to think that it's different.
Okay.
I'm over here. Yeah, you better get somebody from Louisiana to help you out. It's not as different. I get a feeling is.
Well, and we can talk about that for just a minute. We don't have to dwell on it very long, but my recollection was it was largely a sort of a civil code based system from the start, and maybe less common law based. I mean, does that pretty much sum it up?
That pretty much sums it up. It's not necessarily so. I think you see a lot of kind of common law methodology, a lot of stare decisis creeping in, sometimes in the development of areas of the law where Maybe the code doesn't give judges as much cover as they would like. They will look around and apply more common law methodologies. And every now and then you'll talk to somebody like me, or Judge Dennis is one, who are just real fans of the civilian system and the code-based approach. And we will wax on over Sazeracs, of course, about how these common law methodologies are tainting our civil code. But in reality and practice, it's not a whole lot different, I don't think, than the way everybody does it.
Yeah, we've taken a lot more code-oriented approach or statutorily oriented approach in Texas in the last probably 20 years. I
Mhm.
mean, Jody, I think you'd probably agree with me on that. So maybe, maybe we're moving towards each other instead of away from each other, then it sounds like.
I think that's right.
Interesting. Yeah. So, and of course, you've got is it the Louisiana? I know there's the Court of Appeals there in New Orleans that I've walked by a whole lot of times over the
Right.
years. The Supreme Court is there too,
Yeah.
as I
Actually,
remember.
the State Fourth Circuit and the Supreme Court share a building down on Royal Street across from
Right,
Brennan's.
right, right.
Yeah.
Hence the reason I've walked by it
Yes.
a lot of times. So I've definitely seen it. Never been in the building, but would like to
It's a
go visit it
beautiful
sometime.
building. For a long time, this state Supreme Court, gosh, I want to say from some point in the 70s until the early 2000s, was in this sort of big kind of brutalist architecture building next to City Hall, and had moved out of the French Quarter decades and decades ago. But really, former Chief Justice Calagero was instrumental in strong arming and lobbying the various legislators to think about sort of reopening that showcase of justice that was the old French Quarter location. And it's
Hmm.
really beautiful to go into, and it's wonderful to be in, to argue.
Well, that's it. I've got to put it on my list of places to visit. I've had the good fortune of visiting the Fifth Circuit many times and argued in many of the courtrooms there, including the en banc courtroom. And it's always a treat to do that. Yeah, French Quarter to me is just one of those places. It's so historic, and there's just so many different influences there that you see. It's just, we don't have that, and certainly not in Austin. Jody's in Fort Worth, which has its own
Mhm.
sort of unique culture. No, the old cities like, what you have that are just so obviously influenced by a certain cultural set. It's very interesting to me. And you got also great museums and things in New Orleans that are
Mhm.
just a
Oh yeah,
treat to visit.
definitely. And yeah, it is nice to get done with an argument in the state court circuit or in the Supreme Court, and you walk out of the building, and instead you immediately lose all that sort of built up anxiety and stress that went with the argument, because you're in this really beautiful neighborhood and you get to walk past wonderful restaurants and
Mhm.
Mhm.
bars and museums, et cetera, on your way back to the office, because the office is just a 5-minute walk away. And that is nice to have that beautiful surrounding, but also to have it within this very walkable place.
Well, before we venture too far off the topic of Louisiana versus Texas, before we started recording, we were talking a little bit about appellate practice as a specialty in Louisiana. And it's one of the few states that I'm aware of, like Texas, that has a specialization. You've got a body that's I presume, a subset of the Louisiana Bar that regulates the certification process of lawyers to become specialized, as it were. That's our process that we have here in Texas. We've got a pretty sophisticated appellate bar
Mhm.
in Texas. And so, how, how would you describe the state of the appellate bar and maybe appellate culture
Well, it's
in New Orleans, but also more broadly just in Louisiana?
yeah, it is certainly on the way up. I know when I first was wanting to start an appellate practice back when I was at my first firm, and the big thing that I got was, of course, you're too young to start a whole nother practice section. A few years later, when I went off on my own to start my own appellate practice, and very much I was aimed at doing a solo appellate practice and being just focused in on that, I found that I was having to do as much educating the bar about the utility of having an appellate attorney on their team as I was have been. That was as much part of the marketing as marketing who I was and what I do,
Mm-hmm.
Mhm.
to actually educate the bar about just in general what an appellate practice is and how that could be good for them, because it just really wasn't. Except I think there was maybe one firm in town, that really in the whole state, that tried to focus on appellate work, and it was maybe 20% of their work. And it just wasn't something that the bar in Louisiana was accustomed to or really knew what to do with. But in the last few years, so as you mentioned, the Louisiana Board of Legal Specialization has added the appellate specialty to the different specialties that they will certify. It may be, I may not be incorrect about this, the newest of the legal specializations, but it's certainly among the newest. And I actually just got my official specialty certification it was effective at the beginning of this year. It's a very complex, difficult process to go through, which I'm glad for. It's nice to know that there are, I think, 18 now specialized or certified appellate specialists in Louisiana who have run through that sort of certification process. And it's nice to know when I sit in a room with the other 17, these are really well vetted, well qualified, well and highly experienced appellate lawyers who care about appellate law and care about appellate procedure in the very nerdy kind of way that I do. So that process, I think, is a really good gatekeeping mechanism. But like I said, there's only 18 of us right now. I get calls or emails from attorneys from time to time who want to know about that process because they want to do it. And I think that's good. The more of us there are, the more visible it is, then the more attorneys will want to be part of that and will bring their experience and their qualification to it. But I'm saying all that to say that I think the idea of an appellate bar in Louisiana is still in its, maybe not in its infant stages, but in its toddler stages, where I think it is now something that in general, most practitioners are aware, okay, there is an appellate bar and it is a useful thing, maybe in some cases. So there is still a lot of educating the market about the utility of an appellate practice. It's not just a given that, yes, it's a good thing to have if you can afford it. And so I think maybe we're some generations behind Texas in that sense.
We have a lot larger numbers, but we also have a lot of lawyers in Texas. So I had no idea that it was that small, that the club, as it were, was limited to so few people. But hey, Louisiana is at least on the edge in terms of having a specialty to start with and having a developed appellate bar, along with, I can think of Florida and California, along with Texas and Louisiana. There may be more that I don't know of, but it's nice to have the bar recognize the practice area because, obviously there are plenty of good appellate lawyers who don't go through that process, and for whatever reason that is. But it's, to have it be recognized as something that's worthy of getting that kind of separate attention. Right. And it does show that, people want to be, professional and they're serious about studying that practice area. There are plenty of lawyers who have a mixed practice, or for whatever reason, they don't get all here, probably there too, you have to have a certain number of oral arguments, which is getting harder and harder to get.
Right.
And, when you're a young lawyer, it's very difficult to be able to check all the boxes. But I think just the fact that Louisiana has that is, I think, a really positive sign. Plus, my sense of Louisiana, again, I don't practice there, but is that the Bar Association generally, I mean, maybe I should ask the question this way. Anybody who practices appellate law in our state, we have an extremely collegial appellate bar. It's kind of the classic, what things must have been like in the 70s and 80s for trial lawyers, fight all day and, go drink in the bar together at night kind of thing. And I've had great friends of mine that have shown up on the other side of cases. It's kind of a relief when that happens because I know I don't have to deal with somebody that doesn't know their way around, doesn't know what they're doing. But I know this person, they're a good lawyer, they write well, and they won't take frivolous positions.
Yeah.
Is one of the advantages to being up against somebody that focuses on this area. Is it the same there?
Yeah, definitely the same here. I've traveled in the circles of like the environmental law bar and the appellate law bar, and speaking nothing bad about the environmental bar, but there definitely seems to be a much closer relationship among the appellate lawyers here. We see each other often in cases on either side, and the ones who are among those 18, for instance, of the certified ones, turns out those are the folks, the men and women who I've been in appellate courtrooms against, and I'd say the majority of my cases really for the last 10 or 15 years. And the people who have been putting in the work together and respect each other already are the ones, I think, that make sense. They are the ones who would go through the effort of getting the certification nailed down. But they are definitely all people we've sort of We've come up together. Those of us who are the same, vintage, and the ones who are perhaps older are people who we have all naturally gravitated toward as mentors in the profession, and then we're doing the same for the lawyers coming up behind us, and so just organically has created this community of very friendly with each other, very beyond civil and professional, but actually friendly with each other, group of
Hmm.
bar, whether we're against each other or co-counsel or whatever.
Does it cover civil and criminal, or is it purely civil? Or
That's a good question. And because I don't do much in the criminal space, I don't know that I could really answer that with certainty. My guess is, okay, well, let me say, of those 18 folks that I mentioned who have the certification, I know probably 16 or 17 of them personally, and I know that they do civil work. So I don't
Gotcha.
know that the inclination to do the appellate specialization has spread really within the criminal bar. And I don't get a lot of contacts from criminal lawyers seeking our appellate services. And that may be because most of our appellate work is on the federal side.
Yeah.
Makes sense.
We actually have a criminal appellate specialty as well. It's relatively new, but certainly a lot of criminal appeals. And people laugh when I say this if they're not familiar, but we now have 15 intermediate appellate courts in Texas, which is an extraordinarily large number. I mean,
Yes, it is.
I would put us right up there with, California. I don't know how many Florida has, but it's several too. And our intermediate courts handle both civil and criminal appeals.
Mhm.
So there's a real need for the development of a criminal appellate bar. It's the same skill set. It's just more a matter of the substantive law that you're applying. So
Yeah, that's a
now
great.
I can't speak to the federal side of that because like you, I don't do it. Jody, I don't think you do either. It's fascinating. We enjoy having people on our show to talk about criminal appeals because we don't know anything about it.
Yep. It's a very different
Yeah.
animal.
Obviously, there are definitely those practitioners out there who are really good, not just criminal attorneys, but criminal appellate attorneys. The last couple of days, we just finished up the Bar Association of the Federal Fifth Circuit had their annual appellate seminar here in town. I would say probably between a third and a half of the appellate practitioners in that room um, were criminal practitioners. Now, I don't know if they were specifically criminal appellate or if they were criminal who do appellate as part of their practice.
Mm-hmm.
Get
Sure.
my distinction I'm making there, but
Mhm.
very knowledgeable, not just about their criminal, the substantive area, but also very knowledgeable appellate attorneys. So I've actually just started a term as being on the advisory board for the appellate specialization with the Louisiana Board of Legal Specialization. So I think that's a really interesting concept to bring to that board. What can we do to encourage participation by criminal attorneys in the appellate certification process?
Well, I want to talk about a couple of related topics about a blog that you publish called Take the Fifth and some statistics that you put out. But before we go there, I think we've kind of talked a little bit about the idea of building an appellate practice. And I know that you have some thoughts on that. And you mentioned, being up against or having some resistance to building an appellate practice early. One, if you're a younger lawyer, it's really difficult to do. Having done it, I know Jody's been through it. But let's back up into how you went about building your practice, and then just thoughts generally that you have about how to go about building an appellate practice, if that's something that you're interested in.
Yeah, sure. So when I was a young attorney, even when I was being sort of rebuffed by the larger firm I was working at, in the beginning, still what I recognize is that as I gained age and seasoning as an attorney, if I wanted to build an appellate practice, I needed to be an appellate lawyer. I needed people to look at me as an appellate lawyer. So my first step as a young attorney was just to always make sure I was involved as the appellate practitioner on the team of attorneys on any case. And eventually attorneys from that firm would come and find me and bring me into a case that would be up on appeal. And I got really great experience that way. And so was just a very intentional effort to create a reputation as an appellate attorney. And so that's step one. And that would continue in the next firm I was at until I decided, okay, I'm going to give a shot at having my own practice doing the appellate work. The first time I did that, excuse me, actually the first time I also started a blog focusing on appeals. That time it was, back in like 2008, 2009. That may have been, Todd, when you and I first became aware of each other through legal blogging, and I called it the Bartlett blog,
I
BLAWG.
remember.
Sounds good
Yes.
back then. And again, that was just part of that intentional effort to create and develop the reputation as somebody who is focused on appellate matters and who did appellate work. And at that time, I really just, I think mostly was overwhelmed by the education of the marketplace aspect of it. As I was going through that, some of the appellate work I was doing is for a plaintiff's firm here that was doing a lot of the environmental work, which was on the substantive side, what I wanted to be doing. And they did a really good job of being just late enough in paying their bills that on the cash flow side, it made sense for me to go jump in-house with them when they
Mhm.
offered. And luckily, they then paid all their outstanding bills.
That was a condition of going in, right?
But back in with the firm, then it was very much my goal and my design to whatever substantive practice areas they were doing was to have me head up handling all their appellate practice, and just an evolution of that idea of being intentional about putting myself out there as an appellate lawyer with a reputation for appellate skill, and also to get myself out there in the courts and around appellate colleagues, and to be able to create that reputation not just within whatever firm I was at, but within the bar. And that sort of evolution is what led me to where I am now. And what I really like about where I am now at Fishman is there are a few other former Fifth Circuit clerks who work here, and some of them actually were on the transactional side, but just going around and talking to them about uh, the education we'd been doing of the marketplace about the need for appellate practitioners was starting to pay off. Let this firm now put itself out there as having an appellate practice. This is a firm that
Mhm.
wants um, to be a very much a kind of a different kind of beast, not just your general all around. We practice everything, but we are going to do these very specific niches that require sophisticated lawyers and sophisticated analysis, and that the idea of an appellate practice fit very well within that um,
Yeah.
that sort of firm goal. And everybody was excited about it and jumped in to do it. So then it was time to bring back my old Bartlett blog, but as Take the Fifth, and just really again intentionally create a place within the market that people could see these are folks who think about these things and care about these things and do these things.
Yeah.
I don't know if I got away from answering the question or if I answered it.
No,
No, that was
this
great.
is very open ended because I mean it's there's a whole lot of different ways to get started in appellate work. But the approach that you took, I think, is I identify with that 100% because I was in a large firm and the firm had an appellate group, and I was able to do work in that group, and that was good experience for me. I had some great mentors, and we talked a lot on the show about what mentors have meant to both of us, as both Jody and me in our careers. But um, you see, well, for me, it was the idea of I didn't have to leave a firm to do appellate work, but to do the kind of appellate work I wanted to do. It made it easier to leave the firm because I was working in a large firm that had a lot of large cases. And so as a young lawyer, that meant that my role in those cases was really small. And I probably wasn't going to be the guy going, this happened to me more than once. And in cases that went to the Fifth Circuit, as a matter of fact, even though, you're doing all the legwork, you write the brief, it's the client wants the partner whose name's at the top of the signature block to be the one arguing it.
Right.
And so that is a challenge, I'd say, for lawyers within larger firms to develop appellate practice. You've got to, I identify completely with the approach you took of, making it known what you were doing. I always told people,
Mhm.
one of my objectives when I first started out was I want people to know who I am and what I do. Once you achieve that level of, I don't know if you want to call it notoriety or what, but once you achieve that, then things start happening and you can build off of that. Right. So no, I think that's a good approach to have taken. Absolutely. Didn't
and
mean to
and
cut you
not,
off, Tad.
and not a particular easy one. A couple of episodes ago, y'all had on, I can't remember the guy's name, but he talked about the identity crisis, I think is how he put it, of appellate
Oh,
attorneys.
Oh, Kevin
Kevin
DeBose,
DuBose.
That's
the
really
Mhm.
fantastic.
existential crisis. Yeah.
Existential crisis. Y'all tell me if you see this differently, but I really feel like the appellate attorneys I know in the bar here and in the firm here are generally a little less, you know, outwardly gung ho kind of pirates. I mean, they're quieter, more introspective, kinds of folks. And yet to put yourself out there as you're building a thing requires the opposite sort of approach. So it's a real tension to deal with. And that wasn't necessarily part of the specifics of the existential crisis that he was discussing a couple episodes ago, but I very much started thinking about that as I was listening to it.
I think Todd and I probably both agree with that. I think, generally speaking, appellate lawyers tend to be more introverted, and we like to read and work on our briefs and sit in our office and do that. And so you do have to be able to figure out how to harness that energy to getting yourself out there and letting people know who you are.
Right. I mean, this is such a great job, right? Because we get paid to read and write for a living. But I don't think all the attorneys necessarily look at it that way and characterize it that way.
No, and there's a lot of attorneys who hear that and they're like, great, because I hate that part of it. So I'm happy to. I think that's the key, is finding the people that don't like doing it and just let them know that you do.
That's right. I mean, I think you kind of hit it at the right time, though, Tad. I mean, you come out at the time you did. You start your blog, which made it a lot easier to put your name out there than it was before, because the classic, I remember the classic approach that I was taught is, well, we got to get you on the speaking and writing circuit to kind of get your name out there. And that works. I mean, I had some success with that, but being able, I think it's just gotten better for the younger generation now. I mean, if you want to talk about appellate law in a public sphere, you got, unlimited ways of doing that. Now, I'd be shocked if any of us had a TikTok account. I don't think that's in my future, but wherever the audience is where you need to go. And I think at the time, blogging certainly was a great way for someone who might be a little more reserved to kind of, you don't want to toot your own horn too much, but at least you're findable. It makes you that much easier to locate and find. And what I've always found, I think this is still true, was that people would talk amongst themselves. And when blogging was kind of this new and novel thing, there was a lot more buzz about it. And so you probably got approached by other lawyers, certainly, and maybe even judges when you were first out there blogging, saying, hey, you're the guy that writes that blog.
I've been surprised. I did back when I first started that first iteration of it, the Bartlett blog. This, I've been running the Take the Fifth iteration of the blog, I guess, for about 5 years now, a little over 5 years. I started it before I came on here at Fishman and have just kept it going. But I have been approached kind of out of the blue, gotten emails from judges' clerks who I've subsequently talked to, and they say, what we do and what we tell our new clerks to do is to subscribe to your blog, and then they keep folders of my posts where they can, and they say it's actually a quicker way for them to find particular subject matter cases to see, just get a quick review of what the court has been doing and whether their judge or other judges on the circuit on particular issues. And it just blew my mind, because I'm doing this as much for myself, I thought, as other people, but it turns out other people do. I mean, it's a great thing to do to satisfy my own interests in what's happening at the court and educate myself and inform my own ability to talk to my clients about appellate work, but that it is a useful thing for other people in the world. And that kind of blows my mind whenever I think about it or I'm confronted with it. But that is the beauty of the blog. And I don't know what appellate TikTok would look like, but I suppose that would be something because we can take these inner workings of our mind, satisfy them, but also be working in community with other people at the same time.
I think an appellate lawyer with a TikTok account who's actually appearing on video would be sort of countercultural. And not.
That's how you know they're not a real appellate lawyer.
Well, I wasn't going to quite go that far, Jody, but I have to admit I was thinking it because Jody's point, you're right. Most appellate lawyers I know are quieter, more reserved, more analytical. They're not usually the one elbowing to the front of the room, for something to be, they want to say something and be heard. There's a few exceptions. Some people just have natural talent to be advocates, written or spoken, and sometimes both. But that's kind of the rarer bird. But no, I think the fact that you're putting this stuff out there, and we can kind of transition now into talking more specifically about the blog. I love the name, by the way. That's a great name. Take the Fifth.
I was shocked when I did a little research before I registered the domain just to make sure. Certainly there must be a Take the Fifth blog out there somewhere, that there wasn't. So I was like, all right.
Yeah. Well, so you're just kind of scanning through what you've been putting out there lately. As you mentioned, you've got the opinions that are coming out. You've got the annual statistics. I see you just recently released your annual statistics post.
Yeah,
And we can cover.
I run that annual period on a October through September just to kind of coincide with the state Supreme Court, the U.S. Supreme Court both run on October to September calendars, and frankly, that just worked really well because I think I started the blog back in October, but then it's also the annual of the blog itself. The Fifth Circuit puts together their own statistical roundups that they run on a July to June cycle. So my statistics end up being a little bit different from theirs, and I also drill down in some areas that they don't. But yeah, sorry, I interrupted you.
No, not at all. I mean, this is about you. We want you to talk. I'm looking at the statistical post. I mean, it really goes into a lot of depth, and you're giving quite a detailed analysis. I mean, down to, what was Chief Judge Elrod's participation on panels in the majority, authoring the majority. That is really an amazing amount of depth. And I can see now the published opinions that come out daily and filtering that into this table. And so you can really get a sense of what a judge has been up to. One of the Fifth Circuit judges, what they've been up to over the past 12 months by looking at that. And of course, then we see our good friend at the bottom, Judge Per Curiam, which I always enjoy. But so that is quite just an impressive amount of work that you go through to put that together. I commend you on your dedication to doing that, because I know these are things that, these are non-billable hours that you're putting into this project, and for the benefit of lots and lots of other people. It's a great resource.
And there were different things that drive my interest in creating in capturing certain of these statistics. For instance, just coming out of clerking at the Fifth Circuit is where, wanting to know what each of the judges were doing, because, clerking on that court and just sort of being behind the scenes and seeing the dynamics between the judges, seeing, knowing the judges by reputation and by witnessing them is extraordinarily hardworking, well-thought individuals, and just really wanting to dig in and capture that in some sort of empirical, numerical way was something I wanted to do. But then also, as time went by and the makeup of the court changed, I just became very interested in how does the performance of the court change as the judges change. And so those were the drivers behind capturing that particular kind of information. But then also, as an appellate attorney, y'all know clients always want to know, what are my chances? And the lawyer answer is, it depends. It depends on what court you're coming out of. It depends on what kind of case you have. It depends. And they want to know, does it depend on who my panel is? Well, it turns out it doesn't really depend on who your panel is. There were myths about the Fifth Circuit that I wanted to drill down into too, like that the Fifth Circuit is particularly antagonistic toward plaintiffs, which turns out I don't think the statistics really bear that out, that that it matters who's on your panel. Well, the statistics certainly don't bear that out, because there's tremendous amount of agreement between the judges. One of the things I do is I capture what I call an independence percentage. What percentage of the time is a judge in a majority without doing any kind of separate concurrence or dissent. And the lowest percentage was my old judge, Judge Dennis, for the last 12-month period, but he was at 91.67%. That's the lowest not agreeing and completely agreeing with the majority. Most of the judges are in the high 90%. So that means whoever you get on your panel, it's really just about the facts and law. It's not about those personalities of the judges or their particular predilections. And that's what we get all the time in sort of the mass media consumption is, so-and-so was a Trump appointee and so-and-so was a Clinton appointee. Well, maybe some of those social hot button issues that are the ones that make the news, that might make a little bit of difference. Although even in those areas, you see, if you really study these opinions, it doesn't make a huge amount of difference. It's really about the facts and the law. But those cases, of course, are not the majority of the cases that we as practitioners are taking to the court day in and day out, on those bread and butter issues, those civil and commercial, litigation cases, the employment law cases, those kinds of cases. There is almost always unanimous agreement in the panel, and it really is just about the facts and the law. And of course, your ability to properly package the facts and the law into a cohesive narrative that makes sense. But you can only change that so much, even by that practice of skill. Yeah. So as I was saying, really, the biggest driver for me of capturing these statistics was to be able to answer my client's question when they said, ask, what are my chances? And to be able to give them more than just it depends, or more than my anecdotal experiences. I want to be able to give them empirical, percentage, statistics driven answer to that question of what their chances are. And I find that they really appreciate that, even when the answer isn't an answer that they necessarily were hoping for, to give them that dose of, here's the statistically driven reality of what we're facing. And they appreciate that. And then realizing the power of that, then to just share that information, out to the appellate world. I mean, why not? Why shouldn't we all have this information? And we can all have this information. I'm gathering all the information from publicly available sources, so package it and put it out there.
Well, it's an incredible resource. And I'm just thank you for doing that,
Sure.
because it's clearly, as I've said, a lot of work goes into it. And you point out some interesting observations you can make from the data that you've collected. Are there any other trends that you can draw from just looking at the numbers about what's going on at the Fifth Circuit these days? Anything jump out at you?
Well, certainly, there are like little things, and maybe these are kind of little nerdy things that I look at, but you brought up Judge per curiam. One of the things I like to do with the blog is, if I hear one of the judges at a panel at a CLE or something, talk about something that they're paying attention to, is think, well, is there a way I can capture that in these statistics? And Judge Higginson often talks about how he really prefers it, if at all possible, for the judges to have an opinion actually attributed to who they are, rather than per curiam. I mean, obviously, there's a lot of opinions where there's no big development happening, no big disagreement amongst the panel. You get a lot of, for instance, Anders motions on criminal appeals. But that per curiam issue is one that he has brought up. He brought it up just 2 days ago at this seminar that I went to again, but also published versus non-published cases. So I really dig in and look at that. And excuse me, the publication rate at the Fifth Circuit has been creeping up over the last 3 or 4 years. And so I don't know if that is an understanding that, the thought is that we publish the case because, or we designate for publication because it is actually making a development in the law, and is not just a straight application of well-settled legal principles, so there's no reason to publish it. Maybe there's a recognition that more of what they do is deserving of publication because it is making substantive development in the law. Or maybe it's just happenstance that that over the last few, I mean, when I say it's creeping up over the last few years, each year it goes up, 2 or 3 percentage points. Although over the course of 2,000 plus opinions in a year, that's pretty, I think, statistically significant leap. But then it's also interesting to me to see where the court doesn't follow that trend. For instance, yesterday or the day before, there was a per curiam opinion that the court released, but all 3 judges on the panel had separate opinions. To the per curiam was a half a page opinion, but then Judge Ho had a concurrence that was about 12 pages, and I think Judge Richmond had a dissent in part, and Judge Dennis had a dissent in part that were huge. You could tell each one of them probably had written a draft majority opinion, but for whatever reason, it came out as a per curiam with a concurrence and 2 dissents in part. And that gets right into what I think Judge Higginson talks about when you hear him talking about the use of per curiam, or I think in his view, the overuse of the per curiam. That when you're going to be making these distinctions in the resolution of a case, that the parties need to know who's driving that resolution.
Yeah.
And in that case I just referred to, I don't even know what the purpose was of having it issued as a per curiam, because you could read all 3 judges' opinions and figure out who was advocating for what results. So I'm not going to criticize the court or the judges, but it's interesting. And those are the kinds of
That is
things, when
interesting.
you ask me about trends in the Fifth Circuit, what I'm looking at those really granular, kind of nerdy issues of how the court is operating.
Would say so.
Yeah.
What about oral argument? Is there any prevailing trend that practitioners need to be aware of these days? It seems like, you get your notice and they tell you, well, you could be up anytime this window this week,
Right.
usually over 3 days or so, I guess. That was always an interesting thing that the Fifth Circuit does. And then obviously you get more details closer to the submission date. But anything new to you that you've seen in any of the data that you've been looking at?
Not really. I know just personally talking to other attorneys who are practicing in front of the Fifth Circuit, one of the things that people are concerned about is when they have a case that is set for oral argument, but then a week or two before the oral argument, it gets pulled off, and that the oral argument panel is going to decide it just on the briefs. And I know the sooner you find that out, the better. It really seems like, just anecdotally talking to people, they're all frustrated because, like, it happens a week before, and the judges will tell you, well, that's when we're getting the bench memos from the other judges who are on the panel, and that's the earliest we can do it. But when you actually, one of the things I've started doing now with this new October to September cycle is, as I'm reading the opinions, I then also go into the court's docket for those opinions to see what that schedule and what that timeline is on when things are set for oral argument and get pulled off of oral argument. They're actually doing it probably about 2 weeks or a little bit more ahead for the most of the time. So that's one of the things I look at with oral argument. It's just, and one of the things I hope to figure out from this next year of tracking which of these decisions have been orally argued or withdrawn from oral argument or weren't
Mm-hmm.
set for oral argument at all is how important is oral argument. How many more orally argued cases are going to be have reversals or modifications of some sort versus just a full affirmance. Certainly the prevailing wisdom is that getting oral argument must be good for you if you're the appellant, and
Mhm.
I'm curious to see if that's going to play out in the statistics. I've just started
Mm-hmm.
keeping that statistic, so I don't know the answer. But one of the things that I'm starting to see is that, as frustrating as it is to get pulled off of oral argument when you've had a case set for oral argument, it is happening generally with a pretty good amount of lead time. If you count 2 weeks, pretty good
Hmm.
amount. But so far, in the cases that I've seen that were pulled off of oral argument, does not look like it's a harbinger of doom for the appellant. Brief the case in such a way that you made it through screening and got set for oral argument means you've already probably done a pretty good job, because the amount of full affirmances versus non-full affirmances on those withdrawn from oral argument cases is looking to be about the same as ones that were set and remained on
Hmm.
the oral argument calendar.
Okay.
But
Interesting.
that's not a full conclusion. I want to do those
Mm-hmm.
statistics for a full year before I make a conclusion.
Well, look forward to seeing those because that is definitely something to watch. I want to change gears now. We're getting close to the end of our time together, but I did not want to finish our conversation without having a serious right turn in the topic. For folks who follow you on LinkedIn, what I should what I should have started off my introduction of you, I thought about saying, well, we had to reschedule you, Tad, and it's taken us quite some time to get you on the show, but you had you had the best excuse I've ever heard. And I'll just kind of lead this in and we can talk about it for a little bit, not too long, but I do think there's some important things to drill down on here. You were scheduled to be on with us several months ago. And I got an email from one of your law partners telling me that you had been in a serious bicycling accident and that we were not going to be able to proceed with having you record as originally scheduled. And of course, that sounded really serious. The fact that it was coming not from you, but from one of your law partners
Mm-hmm.
gave me quite a bit of information. And I left you alone. I follow you on LinkedIn and I see what you write there. It's useful information there separately. So obviously, that was a big concern. Not only did you have to cancel some obligations, but it was revealed that you had a rather serious bike crash. And I'll let you talk about that process of, what you went through and what it was like to come back from that, because, people have heard you talking now. They can tell, you're if there's a deficit, it's not obvious. I'll just tell you that.
Mm-mm. Not at all.
You're doing a great job of answering questions intelligently, but my understanding is that you actually had a rather serious brain injury
Yeah,
as a result of this crash. So let me let you tell the story after I've kind of set the stage.
sure. Yeah, so I think we were actually originally set to do this recording on February 14th. It was a Friday. No, February 13th was the Friday. Sorry, it was Friday the 13th. That morning is when I had my bike wreck, and I don't know much about it other than what people have told me, because I was unconscious on the road for some time. Then I was in hospitals for about a month, I had multiple brain bleeds. I actually found on my phone the note I took because my speech therapist in one of the hospitals says, well, why don't you practice using this as something instead of like walking around trying to remember things all the time? They like really sort of retaught me how to think and use the resources available to me. But anyway, I'd taken a note of the various specific names, medical names for the brain bleeds I had. But anyway, I was there for a month, and then I was able to go home and do just outpatient rehab for another couple months after that. And I really, from did I say February? Sorry,
You did. Yeah, you
March
did.
13th, March, Friday. That was when from mid-March when I had the wreck. This is one of the things that I have is that sometimes different words come out than are supposed to. But from then until mid-May, I wasn't in the office. I started doing some work from home, if you can call starting the blog backup work, which I do, and just coming in and being sort of like second pen on briefs that people were working on. Starting in mid-May, I was able to come back into the office for a few hours a day, a few days a week. And by the beginning of July, I was able to really be back in full time. But being able to be back working full time, being able to do the things a lawyer does, being able to remember what the law is or, who my wife and children are, then these are the things on the list of things that the doctors weren't sure I was going to do again. So it was very serious. But I had tremendous support, very tremendous support among my colleagues here at Fishman, but also just throughout the bar. Attorneys who I find myself opposite in many cases, they got word of what was going on and they were very supportive and encouraging. Judges who I know around here who either knew or didn't know right away, they would just the amount of professionalism and civility and encouragement that I got from them. And then also clients being tremendously understanding and supportive all helped with that recovery. And so it was a surprise to the people around me as I was able to gear up and do more and more of what it is that I do professionally. But it was a surprise to me too. And really the biggest surprise is as supportive and encouraging as all the attorneys are around me, it was me I had to worry about the most because I think that's probably right for all of us. We are all the least forgiving critics that we have of ourselves,
Definitely.
perhaps with the highest demands on ourselves of anyone. So having to temper my own demands and expectations and be forgiving when I wasn't meeting those was way easier when I could see around me this network of colleagues and family and friends who were overflowing with that kind of forgiveness and encouragement.
Oh, that's really amazing because I did not know the extent. I knew it was serious, but I did not know the extent.
Our managing partner has asked me many times, "Are you sure we can't buy you a Peloton?"
Yeah, and you're pretty hardcore on cycling, I take it.
No, not so much anymore. I've changed my relationship with bicycling, is what I tell everybody.
How could you not in some way? But no, and so I mean, when I first reached back out to you, I didn't know really how serious it was, other than it was serious enough. Rescheduling was kind of obvious, and it coming from one of your law partners and not your assistant or
Right.
something like that was told me a little something. But then we exchanged messages a few months ago, and you told me that you were still in the process of recovering, but that things were going well. And then I was grateful to see you post on, I think it was LinkedIn, as I said, a pretty thoughtful post about, and a revealing and sort of vulnerable post about what had gone on with you and the amount of support you had received. And I just say congratulations because that had to be a difficult
Absolutely.
road to
I appreciate
go
it.
down.
And it's still part of that being easier on myself than I otherwise would be is dealing with, doctors telling me, well, this is going to take a year. You're only halfway through it, that there's still recovery to go. But, I appreciate you using that word vulnerable because one of the things that I've really tried to bring back into the practice with me as I've come back into the practice is, I guess vulnerability is a good word for it, but just, and honesty is another one. We all portray a certain, toughness and go go get itness, about everything we do. Like, of course, yes, I'm going to do that. Never say no to people, but also not necessarily just sort of honestly and vulnerably telling people who we work with and how much we respect and appreciate them for no reason at all, but just because they need to hear that. I've tried to bring that
Mhm.
with me back into, especially with my opposing counsel.
It's nice to see that judges in the bar and your firm could come together and realize that, hey, this is not Tad trying to get out of a deadline.
Mm-hmm.
This is a very serious issue. I mean, I'd say, with brain bleeds, life-threatening, obviously.
Well, I had my first oral argument since the wreck last week, and it was on one of these cases where the room is filled with attorneys who I am opposite in a lot of cases all the time, in front of a judge who I've been in front of a couple of times, not a lot. And I really wanted to, at some point, when the argument was done, to sort of publicly say to everyone, this is where I've been, what I've gone through, and it's my first time back, but I just want to thank everybody for the professionalism, et cetera. But at the same time, luckily in my brain, I don't do that because I didn't want to create some spectacle of
Mm-hmm.
needing sympathy or public sympathy. And I certainly didn't want any idea that I was seeking sympathy because I had this issue in front of the court. So I didn't do that. And then I saw the judge actually 2 days ago out at a bar event at lunch. And I thought, you know what? She's still considering the issue. I can't go to her and thank her. I'm overcome by that all the time, just wanting to thank people, with that sort of gratitude. But I did with all the opposing counsel after we got out of the courthouse. We were standing out on the steps, all just talking. Hopefully, I was able to communicate to that gratitude to them.
Oh, I'm sure you were. I don't know what more to say on that topic other than just I'm glad to see you back. And,
Absolutely.
I know you kind of warned us that you were still recovering. I don't know you that well, Tad, but I can't tell.
No, I wouldn't have known at all.
I appreciate that. I can sort of watch myself inside my brain. I'm like, wait, those words aren't coming out exactly the way that I wanted them to, but I'm on the inside of a little bit. So yeah, if on the outside it doesn't look that way, thank goodness.
I think you're doing all right.
Great.
Yeah.
Well, as we're kind of at our end of time here, our tradition is to wrap up with a tip or a war story. I don't know if you have anything you want to share in our closing minutes.
Well, I was thinking about that. The one more story. One of the appeals I handled a few years ago. Y'all will recall when the New Orleans Saints were hoping for that playoff spot. Where was it? It was in the playoffs against the Rams. And the no call on the pass interference in the Superdome. New Orleans Saints fans are tremendously passionate fans, and a lot of them sued the league. And we're trying to, get depositions of Roger Goodell and a few other. Well, with the firm I was at then, and we do a lot of co-counsel with them now, our main partner has a relationship with Jeff Pash, who's the general counsel at the NFL. And so we had actually had a history of doing work for the NFL. And so they hired us to come in and take care of that. And of course, the elected trial court judge and the state Fourth Circuit judges here, they were not going to rule against the Saints fans. And so we had been, I tell you, talk about ruining my summer vacation. I was sitting there at the beach reading this opinion that the Fourth Circuit had just sort of thrown together and having to do this emergency writ application to the Louisiana Supreme Court. And luckily they're on a longer election cycle maybe. So maybe that, and they weren't all up New Orleans exactly. So maybe they felt a little more insulation, but we were able to get that last case thrown out and on that emergency writ application to the state Supreme Court. So I can say that I've won an emergency writ application to the state Supreme Court. But that wasn't that, as we're talking, realize that's not the war story. The war story really is about how important it is to be good professionals amongst a community of professionals in our lives. So that if you find yourself in a position where you need that return to professionalism, which obviously what I've had this year is sort of an extreme of that, but there are various gradations of that, it pays to always try to be your best as a professional and a person amongst professionals and people, because it comes
Absolutely.
back. That's maybe not as entertaining, but I think that's the better war story to end with.
But that's incredibly valuable. And you did both. You have us a war story and a tip, and those are both great.
That's right. And a perfect way to cap off the episode. Tad, thanks for spending the time with us today. I want to encourage our listeners to check out takethefifth.blog, which is your site. We'll put a link to that in our show notes along with some additional information. And so just, again, we really appreciate you being with us and enjoyed the visit.
Definitely.
Thanks, Todd. Thanks, Jody. This has been fun.